mention. And without further ado, as they say, I'm going to hand things over to Mr. Staples. Thank you.
Thank you very much. Thank you very much for your time, and thank you everyone for attending. You know, I thank you for taking time out of your day. I know that things are very busy lately for everyone, so I'm not going to discuss our law firm or the great things that we've done and all that. You give me a call. I'm more than happy to talk to you about that. I don't think anyone really cares to hear any of that. The only thing I want to really talk about tonight is the nuts and bolts of wills, probate, and trusts. So let's go ahead and get started. There's a lot of false information about a will, what is probate, what is a trust, do I need a trust, do I need a will, what do I do, how do these things work? So, and that's because there's a lack of information. So hopefully by the end of tonight, you'll at least have a better idea of what a will is and how these things work. So let's start with the basics. What is a will? A will is nothing more than a statement by you of what you want to have happen to your probate assets, only your probate assets upon your death. What is probate? Probate is the legal process by which the court system carries out your wishes that are stated in your will. Because you're not here to say who gets what, but your will is, and the court's going to make sure it goes where you say you want it to go. Now, there are a couple other things that I want to discuss, a couple of vocabulary words. One is testate. All it means is that you died with a will. If you are said to have died without a will, you are said to have died intestate. And that's important because a lot of people, like remember I said there's a lot of false information. A lot of people think, hey, if you don't have a will, the state of Florida gets everything. And that's 100% not true. The state of Florida never gets anything. In fact, well, if someone ends up dying intestate, meaning they didn't have a will, there are laws of intestate succession. It's chapter 732 of the Florida statutes, and it deals with every conceivable possibility. That you have some children that are yours, you have some children that are not, like the Brady Bunch, or you have no children, or all the children are yours, or whatever it may be. You have some children that weren't born out of the marriage before you got married to this person, whatever it may be, right? So the state of Florida never gets anything. But what that means is that your assets, your property and everything can be divided in one of two ways. Either you call the shots with a will, or the state of Florida calls the shots with their laws of intestate succession, which may be close to what you want, oftentimes isn't exact, but it might be somewhat close. But either way, your property is going to be divided, and the state of Florida is not getting any of it. The only time the state of Florida gets anything is if it's abandoned, and that's really like bank accounts. You know, they'll send it to the Department of Treasury, but your heirs can even go back years later and get it back from the Department of Treasury. So again, not to beat a dead horse, but the state of Florida doesn't get anything. Wills do not control all assets. That is true. And that comes as a shock to a lot of people. But it kind of makes sense that wills only control your probate assets. They're not going to control your non-probate assets, which makes sense because the process to carry one out is called probate, right? So it only controls your probate assets. The million-dollar question is then, what is a probate asset and what is a non-probate asset? And really that can be boiled down into two categories for each. So probate assets, this is anything titled in just your name. No one else, it's not jointly owned or anything. If it's titled in just your name, your will is going to control it. And also your personal property. And personal property is, your jewelry, your gun collection, coin collection, things of that nature, right? So if it's titled in just your name, or if it is your personal property, then your will is going to control it, right? What about a non-probate asset? A non-probate asset can be categorized in two different categories as well. And the number one is when there's a named beneficiary. The biggest example of that is a life insurance policy. You can put in your will that you want your life insurance policy, the proceeds from it, to go to your friend Stephen. Well, if Stephen's not listed as the beneficiary on the policy, it really doesn't matter what your will says. It has no control over where that asset goes, right? So if there's a designated beneficiary, it goes where you say it goes. You've got to make sure those are right. But what are other examples of designated beneficiaries? You have bank accounts with a POD, payable on death, or TOD, tender on death clause. You have life insurance policies. You have 401ks with named beneficiaries. So if there's a named beneficiary, retirement accounts with named beneficiaries, it goes where you say it goes. Now, the second category is jointly titled property with right of survivorship. An example of that is husband and wife. They call it a tenancy by the entirety, but I don't want to get too lost in the weeds. It's jointly titled property that is with right of survivorship. Now, here's kind of the thing you need to know. If you can title something individually, bank accounts, cars, boats, four-wheelers, houses, whatever it is, you can also title it jointly with right of survivorship. So it matters how it's titled, right? But the big picture here is that, and it's okay to have a mixture of these things. I have it myself. I have a life insurance policy to pay for my children if I end up, dying. It helps put them through college and everything. But as people, married couples are married longer and longer, they tend to hold things more jointly with right of survivorship. So just to review real quick, and then I want to kind of throw a wrench in the equation, and then I'll kind of clear it up. But what is a probate asset? A probate asset is categorized into really two categories. Anything titled in just your name, and number two is when they're your personal property, right? And that is stuff that your will is going to control. Now, what is your will not going to control? It's not going to control a non-probate asset. And non-probate assets, as we've talked about, are when there is a named beneficiary, like a life insurance policy, things like that, or when it's jointly titled with right of survivorship. Now, let me throw the wrench in the equation. Something can start as a non-probate asset, move to a probate asset, and then move back to a non-probate asset. And that sounds kind of crazy, but let me kind of give you an example. And it's kind of an extreme example, but hopefully it reiterates the point. I have a $2 million life insurance policy. I really do, actually, that lists my wife as beneficiary, right? So let's say that I walk out of my office tonight after our seminar and I get run over by a car outside my office. Well, does she have to ever go through probate to actually get that money? The answer is no. She ends up showing a certified copy of a death certificate to show that this person, my husband's no longer living, and a photo ID, and they give her a $2 million check, right? The moment she cashes that $2 million check, she's cashed it in a bank account that is titled in just her name, right? So what happens then? Well, now it's a probate asset. So if she walked out of that bank after cashing that check and ends up getting struck by lightning and dies, well, her will is going to control it, right? But let's say she doesn't end up getting struck by lightning. Let's say that she goes out and finds another guy that she marries, and she is never going to be as happy as hopefully she is with me, and she'll never find someone as good looking as me. But let's say that she does, right? And if she ever puts that person on there jointly with right of survivorship, and at that point then gets struck by lightning, well, she's changed how it's titled, right? So now it's jointly titled with right of survivorship. So upon her death, whoever that new person is going to own everything outright, right? I'd haunt her if she ever did that, but let's say she did. Well, what happens if she doesn't do that? Let's say that she never ends up changing it jointly with right of survivorship. It could be 20 years later. It doesn't matter when it is. It just matters upon your death. How was it titled? Was it jointly with right of survivorship, or was it just in your name? Your will will control it if it's just in your name. Otherwise, it will not be a probate asset because it will pass to the person who is surviving. Next is estate taxes. Now, in Florida, you don't have to worry about estate taxes. Number one, Florida does not have an estate tax. However, you're still subject to the federal estate tax, which is currently about $12.92 million for an individual and his husband and wife. It's $25.84 million. And so as a result, for me and all my friends, I don't have to worry about estate taxes. But if your personal assets hit the federal threshold, then yes, you will be subject to it. But for the most part, me and all my friends are fine from it. So it's not something you have to worry too much about. Now let's talk about the format of a will, or what we call the scheme of distribution. But before we get there, I'd like to go over a couple ground rules, okay? Number one, your will does not have an expiration date. It's just as valid the day you die. It could be 100 years old if you can live that long. It's just as valid the day you die as the day it was drafted, okay, as long as it is properly done. Number two, no child has a right to inherit. You don't have to leave them a dollar. A lot of times people come to our office and they say, "Look, I know I got to give my son a dollar or my daughter a dollar." Like, no, you don't. You don't have to. But remember rule number one, which is if you get back into good graces with Junior, you really want to change your will and give Junior back, put him back in your will, because Junior's not going to get anything. So, and lastly, Florida will end up accepting wills from other states. I can't say that those other states will accept them from Florida. So, what I mean by that is if you have a valid will that was done in Texas while someone was in the military, and then you get stationed in Florida for whatever reason, Florida will honor that Texas will. I can't tell you that Texas will honor a Florida will because I'm only licensed in Florida, but I can tell you that Florida will honor wills from other states. Now, when we talk about the scheme of distribution, a lot of times, people come into our office and they're welcome to tell me what all their assets are worth. But quite frankly, I've never seen anyone that was right on death's door. So by the time someone passes away, your assets are going to change very differently, most likely. So that's why it's very important to know, what is your will going to control? What is it not going to control? How does this stuff work? Um, so the scheme of distribution, ultimately, there are two ways in which you can give stuff to people, right? Number one is per capita. Number two is per stirpes. Sounds like a bad word, but it's not, right? So per capita, okay, you have two children. You have A and you have B. In order for that child to inherit anything from you, they must be living upon your death, right? So let's say that, before I die, my child B dies, right? So my child B dies January 1st of 2024, and I die January 30th of 2024. Well, if my will was done per capita, B was supposed to be living to receive anything upon my death. So B's heirs and family members are going to get nothing. It's all going to A, right? Per stirpes is very different. Per stirpes, whether you are living or not, the grandchildren will end up receiving it. So let me give you it'll go to your heirs. So let me give you kind of an example. An easier way to kind of think of it, at least for me, is per capita. I love my kids, but my grandkids are worthless. They're entitled. They won't come see me. They won't get a job. All they do is hang out on a phone. They never want to come see me. So I'll tell you what, I really want to take care of my kids. My grandkids, they can fend for themselves. Hey, not a problem. Per capita is your guy. But per stirpes, I love my kids and I love my grandkids. I want to make sure that I take care of both of them. Not a problem. Whether A is living or B is living, whatever it is, that child, your grandchildren will end up inheriting, whether they are alive or not. Now, let's talk about probate, okay? Now remember, probate is the legal process by which we carry out your wishes that are stated in your will, because you're not here to say where you want stuff to go, but your will is here, and the state of Florida is going to make sure that the judge is going to make sure it goes where you say it goes, okay? But there are two forms. It seems like there's two of everything, but there's two types of probate. Number one is summary administration, okay? Summary administration can be as fast as about 5 weeks, but realistically, it takes about 2 months, maybe 2.5 months, because a personal representative is not appointed. You don't have to publish in the paper, and it costs about $500 because you have court costs and that stuff to end up opening the case. Now, formal administration takes about 8 months. You have to have a personal representative appointed. It runs about $750 because you have the court cost as well as publication fees. You have to publish in the paper, and a personal representative is appointed, right? So how do you know which one you're going to do? Why would anyone ever want to go through formal administration if you can go through summary, which seems way less painful, right? Well, before we get there, let me discuss briefly homestead. Let me discuss briefly what homestead is. Okay, there are two types of benefits from homestead protections. Number one is a creditor benefit, and number two, as most homeowners know, is a tax benefit. You pay less on taxes, right? Well, the creditor benefit, basically, in order to qualify, anyone that knows O.J. Simpson, that case, where they got a judgment against him, he moves to Florida allegedly and buys this big house or whatever, and they aren't able to collect from it. The way this works is in Florida, in order to qualify, you can only have one house that qualifies. So if you have multiple houses, pick the nicest one because that's the one you want for homestead protection, right? Number two, it cannot be any bigger than half an acre in the city limits or no more than 160 contiguous, meaning joined acres out in the country. So you can't have 100 acres here and 50 acres down the road a ways and another couple miles down the road, 20 acres and things of that nature. It doesn't work like that. You have to all have it joined, right? And lastly, it must be left to your bloodline or legally adoptive children. So if you end up leaving your portion, a portion of your house to your best friend Steve, and he's going to share equally with your son Michael, right? Well, Michael's portion is protected from homestead protection because that's bloodline. But Steve's protection doesn't exist because Steve's not bloodline, nor is he legally adoptive. Now, what I mean by legally adoptive, it's not, hey, we loved, little Timmy. We always thought of him as our own. No one's saying that you didn't. But in order to have the legal protection from creditors, meaning any bill collectors, any Medicare liens, things of that nature, you must end up passing it to bloodline or legally adoptive children where there is a final judgment of adoption, because that considers them to be bloodline in Florida. So now that we've talked about that, right, let's come back forward and talk about probate. So how do you know which one you're going to end up doing, right? If the value of the assets in the property, in the estate, are, without considering the homestead property, are over $75,000, you must do formal administration. If it's under $75,000, you may do summary administration, right? Now, let's review briefly. So we know that probate assets are going to be anything titled in just your name and your personal property. Non-probate assets, which are not controlled by your will, are going to be when there's a named beneficiary. And number two is when it's jointly titled with right of survivorship, right? Well, let's say that I end up, when I die, I end up having I have a $2 million life insurance policy, which I actually do. Let's say that my house is worth $500,000, right? But it's homestead and it's on less than a half an acre in the city limits. Which I don't know, I don't know where house is worth, actually. I don't know if that's true or not. Let's say that I have a 401k with another 600,000 in it, which lists my wife as the beneficiary, just like the $2 million life insurance policy. And let's say that in my personal bank account that only has my name on it, I have $30,000 in it, okay? Well, what are we going to do? Well, let's look at the assets personally. So the $2 million life insurance policy has a beneficiary listed as my wife. So that's a non-probate asset. It's never even going through probate, right? The $500,000 for the house, that's homestead. We're not even considering that. The $600,000 in my retirement 401k account that lists my wife as beneficiary, that's a non-probate asset, right? So that, and I'm not saying those numbers are accurate, but let's, that's a non-probate asset. So it's not even going through probate either. And the $30,000 in that's alleged to be in my checking account, now, is that under or over 75,000? Well, it's under. So we can do summary administration here. That's kind of how it works. So probate is not this terrible thing that you have to worry about. I know there are a lot of horror stories out there, and they're really not true, at least from what I've seen. So anyway, that's what probate is. Now, let me discuss one thing real quick that's not on the slide, but a lot of people that come into our office think that, hey, look, the personal representative, that person gets to decide exactly what's going to happen with your property. No, they don't. Okay. They literally hold on to the property and they manage it until it goes where you say it goes. And that's why they're only really appointed in a formal administration, because it can take about 8 months, right? And so during that time, if you don't make a mortgage payment, they're going to start foreclosing on probably most people's biggest asset, their house, right? If you don't pay the power bill during the summer months when it rains all the time, they're going to cut the power off and you're probably going to get mold growing in the house. They make sure that, the bank is aware, or the credit union is aware, hey, my dad died. We're going to settle everything. You're going to get your money for the car payments and everything. Please don't come repossess it. I promise you we're going to work with you. So that they manage everything until it goes where you say it goes, right? Now, let's talk about personal representative and attorney's fees. A lot of people think that, look, man, the state of Florida gets a big chunk of your estate. The attorney takes another big chunk. I mean, really, your family really doesn't get a whole lot. And that's 100% false. That's not true at all. First of all, we know the state of Florida doesn't get anything. But second of all, attorney's fees are limited to no more than 3% of the value of the estate. So if you have an estate worth $200,000, the most an attorney could physically charge you for the attorney's fees is $6,000. And we always give people a break because we want them to come see us. So it's not this crazy expensive process. And personal representatives are also entitled to up to 3% of the value of the estate because they have to run around and do stuff. They have to go check out banks. They have to do all kinds of stuff with creditors. Oftentimes they don't, though, because usually it's a child. But the point is, it's not this extremely expensive process that everyone's so afraid of. That's not honestly what it is. Will contest. I won't get too in depth on this. Can you contest a will? The answer is absolutely. You should use the court system if you believe you're wrong. Don't revert to self-help. Of course, the state does not want anyone to do that. But there are two ways in which to actually contest a will. Number one is by undue influence, right? So if you could end up proving that someone coerced or forced someone to change their will. So let me give you an example. Hey, Dad, I know that you're bedridden and you're not able to move or do anything. And I use your money and I pay your power bill and get you food and all this. If you don't change your will to cut my sister out, I actually do have a sister, her name's Mary. If you don't change your will to cut Mary out and give everything to me, then I'm going to quit doing this stuff and you're going to sit here in the dark and you're going to starve to death. So sign right here. I mean, no one really ever does that in public. I've never seen that. I've never seen stuff that egregious, but that's one way. But no, I've never seen anyone really try to fight that. The second way someone's going to end up trying to is really the one way that you actually really see people try to do a will contest, if ever, but it's by lack of capacity. In order to have a will in Florida, you must be oriented to time, place, and circumstance. So really, it's kind of the whole concept is this. The state of Florida really doesn't care who you give your stuff to. It's just that they want to know that it's freely, knowing, and voluntarily done, that you knew what you were doing, you intended to do it, and no one really put pressure on you, and it was voluntary, right? That's really what they want. So lack of capacity, really how you do that, and I don't know anyone that really wins these, honestly, but ultimately, as people get older, they tend to have doctor's appointments quite often. So you end up, the way to prove it is, well, when they went to the doctor on January 1st to see their primary care physician, they didn't know where they were. They were totally out to lunch. When they went back on January 10th to their neurologist, they didn't know who they were, right? But here's kind of the thing: people have good days and bad days. And one of my more favorite movies is The Notebook, right? Where this gentleman is reading a book, and I don't close your ears if you haven't seen it. It's a good movie; you should definitely see it. But anyway, this gentleman is reading a book to this older woman who appears to be in a retirement home, and at a certain point, she realizes, "Hey, it's a story about us, right?" Well, if she made a will during that moment where she knows that it's a book about us and she understands what's going on, right? It would be a valid will, right? But then as soon as she, doesn't know who he is anymore and is afraid of him, well, now she doesn't have the ability, right? So you have to kind of prove that no will was done during that time. And it's very difficult to do, especially if an attorney is the one doing it, because we have an ethical obligation not to do wills for someone who you have a question about. So at the end of the day, is it something you need to worry about? Absolutely not. I've had people inquire. I've never had anyone hire me because here's more or less what I tell them. It's a $10,000 retainer plus another $5,000 in expenses. They bill me out at $250 an hour, and there's less than a 1% chance that you're going to win. More importantly, I don't believe that $10,000 is going to be all that it takes is for attorney's fees, or $5,000 for cost, especially if we end up going to a trial, because we don't know what experts we're going to have, and doctors don't show up for cheap. I can tell you that. They don't. So you can spend quite a bit of money, and thus far, I haven't had anyone come back to hire me. So it's not something you need to worry about, but you need to know that it does exist. Now, trusts, there are many different types of trusts, okay? But the two I want to talk about, and first of all, I want to talk about a revocable living trust and then a testamentary trust. But before we get there, I want to discuss really the elements of a trust, okay? In law school, they taught me at least, there are three elements of a trust. Now, in reality, there's really five. When I started practicing, I realized that. But the three they teach you in law school is number one, you have to have a beneficiary for the benefit that the trust exists, right? Number two, you got to have a trustee to manage the trust for the benefit of the beneficiary. And third, it's got to be funded. There's got to be something for the trustee to manage for the benefit of the beneficiary, right? Now, the two they don't teach you in law school are, or at least I didn't see, is that there's got to be a beginning and an end date. They don't end up lasting forever, okay? Now, let's talk about a revocable living trust. A revocable living trust, honestly, I've never seen anyone that truly needed one, and I believe Mr. Stacy will be able to tell you even more about that. But ultimately, the big come on was, hey, it'll prevent everyone from knowing what your estate is worth. Right now, the last probate that I filed, I think was 2000, 2023 probate, the CP, I believe is what it is, and then it's the case number. And I think it was in the 3000s or 2000s, which means there were at least 2000 and whatever people that opened probates before that. Does anyone know what their estates were worth? Because I don't either, honestly. So yeah, no one's going to know what your estate is worth in a living, revocable living trust, but they're not going to know with a probate either. That's just not really how it works. They'll also tell you, hey, you can, save this amazing expense of probate. Number one, and I think a lot of people probably mix it up. We do auto accidents and personal injury and stuff like that, where it's a contingency fee, where we only get paid if and only if we recover, right? But probate doesn't apply under that, where it's set at that 3%, not 40%, like personal injury, especially if you file a lawsuit. So I think people are kind of mixing that up. But here's the kicker with trusts. Remember, I said they don't last forever. So what is probate? What's the process of unwinding one? It's called trust administration. It's probate for trust, is what it is. The kicker is the attorney's fees are the exact same as in probate. It's just 3% of the value of the trust assets versus 3% of the value of the probate assets. But it's the same thing, right? And I could go on and on and on. I won't belabor the point, but I've never seen anyone that honestly needed one. Honestly, I think they're kind of a borderline fraud. But at the end of the day, it comes on a PDF where you get this disc and you put the person's name in it and it goes through all these documents and everything. And you'll get a really pretty binder and it looks wonderful, right? But at the end of the day, it's just not really in most people's best interest, honestly, because I'm not going to tell you something that you want to hear. I don't think my Pensacola would want to associate with us if we ever did that. We've been associated with them for almost 40 years, I think. So anyway, but not all trusts are bad, though. And there are many, many different types of trusts. But one trust that is not bad is called a testamentary trust. Now, that is only created out of your will, okay? And it's only created if something special happens. So, in fact, I have one in my will, right? And in order for it to come into place, number one, I'm dead. Number two, my wife's dead. Because if she's alive, she's going to manage this $2 million life insurance policy for these two kids. I've got two children, right? Two daughters. Because if you give $1 million to an 18-year-old, they're going to have a really sweet vehicle, or they're going to blow it, right? They're going to have a motorcycle, all kinds of terrible stuff. So the whole point of a testamentary trust is for spendthrifts. It's for children that have drug issues. And here's an honest to God real life example. I had a gentleman that came into my office one time, and he had a pretty sizable estate. It was about $3 or $4 million. And he said, my wife, and he was in his 90s, and he said, his wife had just recently passed away, and he promised her on her deathbed that he would always make sure their son had a place to live. His son was in his 50s. The problem was his son had a terrible drug issue, apparently. So, if I give my son this kind of money, he's going to die with a needle in his arm in the next couple of weeks. I mean, I can't in good conscience do that. So, hey, that's not a problem. A testamentary trust is perfect for you. So The testamentary trust for this gentleman was going to extinguish on his child's 50th birthday, or I'm sorry, on his child's 90th birthday, assuming he lives that long, right? But ultimately, the whole point with it is it's for children that, aren't 18, right? It's for, or whatever age you have. So for us, my wife and I decided to terminate our trust when our children reached 27. Because I figure after that, they ought to be mature enough to manage their own money. And it's kind of on them at that point. But the whole purpose is to have someone manage it until they can get through high school and college and grade school or whatever, if that ever becomes a problem. And if it doesn't, and they're after the point of 27, it just doesn't get created, right? So that's living trust, or that's testamentary trusts rather. Now, prenuptial agreements are valid in Florida. Okay, they're not a romantic document in any way, shape, or form, but they are valid. There are two elements to them, and I want to go over those first, and then I want to kind of explain why you're hearing about them, because most people don't really want to hear about that. The two elements are, number one, there must be full financial disclosure. And really, the seminal case, the one that I learned, was there was a gentleman in Fort Lauderdale that told his wife he got married to another person and said, hey, the prenuptial agreement said, hey, my estate is worth $10 million. Well, it turns out his estate was worth about $100 million. So ultimately, what the court found was you can't knowingly waive your interest. Your wife didn't knowingly waive her interest in your property because she didn't have knowledge of what your property was really worth, right? So they refused to honor that because he didn't give full financial disclosure. So you've got to give full financial disclosure as the first element. Number two is that they must have the ability to have an attorney review it. It doesn't mean they must have an attorney review it, but they have to have a chance to have that done. So you can't say, hey, I know we're about to walk down the aisle and get married here in a second, but I need you to sign this. Otherwise, if you don't sign it, I'm not walking down there right now. Well, if you could prove that, it wouldn't be held up. So those are the two elements. Now, here's really how they apply for people today. As people are, generally men die before women, right? So we've seen a lot of times where there are second marriages very late in life. Some people get remarried in their 60s, but my great grandmother lived till she was 104. My grandmother lived till she was like 96, I think. So if my husband died, if I was a female and my husband died when I'm 60 or 58 or something like that, I don't know that I want to live, I may not want to live another 35 years by myself, right? But here's where it comes into play. If you get married, the law changed in 2012, right? Where these second marriages, if they don't have a prenuptial agreement, your spouse has an option for the homestead property that y'all are living in, right? So let's say that I pay my house off after 30-year mortgage, and I end up getting remarried because my wife has passed away, and then I die. Well, if we were living near, if it qualifies for our homestead property, now my next wife has two options. Number one, she can either live in my house until the day she dies, and it's known as a life estate, right? But she has to upkeep it. She has to pay the taxes. She has to do things like that, pay the mortgage, whatever it may be. But she also has now a second option, which is within 6 months, that person can opt to sell the property and keep half the proceeds. Well, the issue is most people's biggest asset is their house. So a lot of people are like, look, I don't mind if my second spouse lives in it, but look, their mother and I, spent our life buying it, and I want to make sure my children get this house or get the proceeds from it, whatever it is. But I want to make sure that you're able to have a life estate. So the purpose of this is you can have the person do a prenuptial agreement so they don't have the ability to sell it, and you can will them a life estate. So you can have exactly what you want to have done, but you can ensure that they don't have the ability to sell your house and keep half the proceeds from your children. And lastly, we have a prepaid legal plan that's through My Pensacola. It's only open to members, and it's $156 a year. It covers you and all your dependents for tax purposes. It doesn't cover pre-existing, but it covers, so you can't say, hey, I just got arrested for a DUI. Where do I sign up for this plan? Or I just got served with divorce papers. Where do I sign up for it? But it does cover divorces, criminal. I've actually done a murder on it for a client that was, their family was covered under it and they were dependent. So it covers an awful lot of things. But I can get into that a little bit more. I don't want to belabor the point. But we do have that. And if y'all have any questions, I'd love to chat with you guys later. And I thank you guys very, very much for allowing me to come chat with you. And I believe my friend, Mr. Chad Stacy, is going to pick up.
Thank you, Tommy. Amy, just want to make sure my screen looks good to you. That's still
Yeah, Tommy, if you could stop sharing your screen and then so Chad can take it over, that would be great. All right.
I'm sorry about that.
No, you're fine. And Chad, it's all yours. Take it away, please. Thank you. And thank you, Tommy.
Thank you, Amy, and thank you, Tommy. That's a great presentation. My name is Chad Stacy. I'm a financial advisor. I own my own firm, Stacy Financial Group. I'm an independent financial advisor. I've been doing this for about 18 years, almost 19 years. It's hard to believe time has flown by like that. Most of that time here in Pensacola, I have worked primarily with credit unions. A lot of members from credit unions throughout town, whether you're at my Pensacola or one of the other ones. I love working with credit unions. After going through the financial crisis in 2008 and 9, where the credit unions really, they really showed well. I mean, they didn't have any issues, and you had banks failing everywhere. So I'm a big fan of credit unions, credit union members, and I love working with those members with their retirement, their investments. Yeah, I know that a lot of the membership at this particular credit union, my Pensacola, originally comes from city employees, city workers, things like that. I know it's really branched out at this point. One thing that I focus on with my clients, obviously, is their retirement and the investments that they choose, the type of retirement accounts that they have. I do have, the slideshow does kind of go into some of those different things. So I want to kind of touch on those, here and there. I don't want to get into too much detail or read about that. I'm happy to answer those questions at the end. But one thing to start out with that I would like to share with my clients is, I'm definitely I'm not a salesman. I'm an educator. My job is to help my clients understand whatever it is they're coming to me for. If it's help with their retirement plan at work, if it's help with their personal savings, their personal IRA, if they had a death in the family and they have some inheritance money, possibly something that maybe was referred over from Tommy's office, dealing with an estate or something like that. Those are some of the components that I work with. And it's never a sell. It's always about education. I find that when I can educate my clients to make a good decision about, with their money, where they want their money to go, and put the control into my clients' hands and keep them in control of their money, they seem to end up very happy, or happier rather than if someone else is controlling their money. But so going into that, I've worked with members and clients all over town that might be with the city. They might be a teacher. They might be an educator in the school system, and or they might work with a public company or private company in town. So most of you, if you're on this call, if you are still working, you probably, if you're employed, you probably have some sort of retirement plan. If you're with the city or the county or the state, then you're probably familiar with the Florida retirement system and some of the different buckets that they have for you, whether that's a pension or an actual, the 401k part of that. If you work at a hospital, you might have a 457 plan. If you work in the school system, you might be supplementing your retirement with a 403b plan. I say these different numbers of the different plans because there are several different plans out there, and it just kind of depends on where you're employed and through whom you're doing your retirement. But they all basically do the same thing, which is they help you to put away your own money, and then most of the time the company or the city or the county or state, there's also a match component to that where the employer is putting some money into your retirement account. But ultimately, that whole process was put together to help you have money at retirement at the end of the day to live on. I'm not sure, we don't have a lot of major car manufacturers down south. You probably heard the stories from back in the day when you had these folks that worked at Ford and General Motors for, let's say, 20 or 25 years, and they're 45, 50 years old, and they retire with a huge pension that's paying them probably 75% of their income, and and then they're staying alive for another 45 or 50 years. I use that example to just to tell you that pension systems are going away in our country, and as we know it, because of the fact that there's they people are living longer, and the money is running out at the end of the day, and so it's really putting a lot more weight on us personally to save our own money for retirement. And if you're currently in if you're currently in employment where you do have a pension, that's fantastic. But I'm willing to bet you that there are some other components or other voluntary options that you might have on top of that. And talking about the pension, you go down to Social Security. I'm 42 years old. I'm not sure if Social Security is going to be around when Tommy and I decide to retire, 20, 25 years from now. About the strains on Social Security. And so that's why when you look at this slide on the voluntary savings, whether it's a 401k, 457, if it's your own IRA or maybe a Roth IRA, it's extremely important to try to take control of your own retirement savings these days. It's great to have help from your employer, but a lot of my education to my clients and credit union members is to try to make sure they know, listen, don't just rely on whatever that pension is. Try not to rely on just what you're going to get from Social Security whenever you turn that on, whether you choose to do it early at 62 or try to wait until you're 70 or 72. You're going to need more savings. Those are some of the points that I like to go over with my clients. I will tell you, I am very versed in at least the Florida retirement plan, the FRS system. I'm very versed with the city of Pensacola and their pension and their defined benefit plan. So I know about these different plans that are out there, and later on, if you have questions about that, please run those by me. One thing that I tend to hear a lot of is typically when clients come in toward the end, when they're getting ready to retire, or even if they're starting to plan that within the next 3 to 5 years, is that they've been part of this plan for 20, 30 years, however long it is, but they don't know how it works. They don't know there are several different choices at the end of the day that they need help understanding. And again, that's why my job really goes back to education on how these different kinds of buckets work. You can see the little nest egg right there. These are different ways that you can participate in the retirement vehicles, whether that's with your company or whether it's your own IRA these days, a traditional IRA, maybe a Roth IRA. Those contributions, for example, backing up, if you're with a company, if you're employed and you have an employer-sponsored retirement plan, most of those plans these days, you can make contributions either pre-tax or after tax. The Roth, what you see there, the Roth feature, a Roth contribution to either an IRA or to a retirement plan is an after-tax way of putting that money in the plan. Now, a lot of folks have a little bit of confusion on, okay, which one's the right way for me? Should I do the pre-tax contribution so that I can get deductions on my my annual income, or should I put in after-tax money for down the road? typically what the rule of thumb I give is 10 years. If you have 10 years or more to work, absolutely a Roth after tax contribution feature is probably the best idea for you, unless you are potentially maxing out your contribution to your 401k or your employer sponsored plan, and you're doing it in a pre-tax way, and your CPA or your tax professional is telling you that you have enough benefit of that contribution to deduct, those amounts of income on an annual basis, that's okay. But most of the time, that's not the case for most workers out there. The biggest advantage to that Roth or after tax contribution feature is the fact that down the road, every dollar of that money, including the gains, any money that you make in that, whether it's interest or gains from market activity, every dollar of your money is coming out tax free when you retire at the end of the day. When you put in pre-tax contributions into your 401k, your traditional IRA, your 403b, your 457, at the end of the day, when you retire, every dollar of that money is going to be coming out as taxable income. So you might be getting a break on it right now while you're working, but you're going to pay tax on it down the road. And I think that we can all agree. And if I asked you, do you think in 20, 30 years, do you think taxes and tax brackets are going to be higher or lower? I think everybody would probably agree that taxes are on the rise. They always have been, and they always will be. So that's one of the features that I always talk about. The catch-up option. When you turn 50 years old, most plans offer you the ability to put more money into your plan than you could before you were 50. For several of the different options, and I'm going to skip down a couple. I wanted to get to this screen so you can kind of see some of these figures. When you get to, for example, with a regular 401k, 403b, 457, most companies, they allow you to contribute up to $22,500 when you're 50 years old and older, and that's also included with a regular IRA. You are allowed more money to quote unquote catch yourself up and get more money into the plan until you retire. That's another benefit of being able to add more money to your plan as you get older and as you get closer to retirement. I do like this slide because it shows, and especially if you're a city worker, city, county, state worker, a lot of you may have gone straight to work out of high school. You might be getting close to that retirement age, or well earlier than most other employees, based on when you went to work. And so the state has really done a good job, in my opinion, of putting a rule in where at 55 years and older, if you're separated from service, you can go ahead and start taking your money without any penalties. Otherwise, you have to wait until you're 59 and a half, and before you do that, there might be some penalties involved, including a 10% early withdrawal penalty. So I don't want to get into too many weeds, but I did want to try to separate some of these plans and some of these ideas for you in your head. And again, that's one thing that I really try to work with my clients on and different members, is just helping to educate folks on how their particular plan works. If you have a pension, we want to know what that pension looks like down the road when you're getting ready to retire. And most companies have the ability to forecast between 3 and 5 years out what your actual pension in your annual or your monthly payment would be if you continue to do that. I always encourage my clients and members to try to get some of those forecasts when you get to that point. It's always a good idea, and at the same time, Social Security can do that for you too. You can get an idea. You can get kind of a ballpark figure of what you should expect with from your Social Security payment, as well as your pension. So along with the different options, the other options to help fund your retirement, besides your pension and Social Security, these are all ways, they're all tools that are there for you to use to basically save your own money for retirement. And again, if you're with a company or even with the city, county, state, most of those also have the ability to do a match. So there's a big incentive to put in some of your own money into these plans because you want to take advantage of the match that your employer gives you, whether that's a 2% match, a 3% match. Some companies are a little richer and they even go up to 5 and 6%. But just remember, if you're part of a company that does offer a match, please take advantage of that. Not most of the time you have to match dollar for dollar up to whatever that percentage is. But if you don't put your own money in, you're basically leaving bonus money on the table that your employer would otherwise have put in that account for you that you can take home at the end of the day. Very important, So again, these are just all the different things that I like to go over with my clients to help educate and make sure that they know how their plan works. They know all the bells and whistles inside of it. And then especially at the end of the day, we want to know how all this is going to work because we don't want to be blindsided when you walk out of your employment, when you retire and you come into my office and say, okay, I'm done. Some people have a blank look on their face. They don't know what to do. I would so much rather get you into my office, 6 months, 1 year, 2 years beforehand so that we can plan, we can prepare for that day so that it'll be an easy transition. We talked about the different types of retirement vehicles. Again, individual IRAs. If you're with a company and you're doing whether a 401k, 403b, if you're in the pension, most of the time you still have the ability to contribute to maybe a Roth IRA, traditional IRA. But I would tell you, if you're in, for example, if you're in a 401k and they have the ability, or you have the ability to contribute up to $22,500, and you're only putting in, say, $10,000 a year, there's no reason to open up another IRA somewhere at the credit union or somewhere else and put different money in that account when you can put all of it in the same retirement vehicle. So, again, it's just a word to the wise. Unless you're maxing that plan out, use the plan that you have to your advantage to put more money in. If you're at that max and you need some more options, that's great, and I can help you with that. But most of these company retirement plans, they have some pretty high contribution limits for you. So of course we can always talk about that in my office or whenever you'd like to, maybe at the end of this presentation. We went over the Roth IRA, the Roth, the after tax option. Again, if you have not taken advantage of that option and you've got between 2 and 5 years to retire, it might not be worth it to make that transition. But in my opinion, clearly, if you've got 10 years or longer to work before you retire, I would say absolutely. I think most CPAs would agree with me. Unless you were in a very high tax bracket, the Roth contributions make very, very good sense for you. Some of the different things that, and we can talk about some strategies and risk and things like that in a second. But basically, I kind of go down a chart. And one reason I really love partnering with Tommy and his firm is because our businesses go hand in hand. I mean, he's doing estate planning for his clients, and my clients need estate planning. And going back to some of the things Tommy said, when you have a 401k or an IRA or maybe even a trust, or you've got a regular investment account that's either jointly owned or you have a TOD on it, with beneficiaries, all those assets are protected. And I work as hard as I can to protect every account that my clients have. But to Tommy's point, my clients have other assets out there too. They have cars, they have houses, they have physical assets, and they have things that that would probably be going into a probate court or something like that. And so though every one of my clients needs help from an estate planning attorney like Tommy. And I'll put this in there for him. The prepaid legal plan that they have is an outstanding plan. I refer so many of my clients to Tommy and to that plan because for the money, for what you sign up for, to be able to get them to put together a will, power of attorney, healthcare instructions, any of the different, issues that can come up throughout anybody's life with legalities. Um, from my experience and from my clients' experience, they do a really good job with that. So I'm really happy to be able to partner with somebody like Tommy, because obviously, when I work with my clients, it starts off with, what are we going to do for retirement? What's my income going to be looking like? What do I do with my money? Where should I invest it? And then I'll go through a little bit of some market information for you at the very end here. But that's my job to start off with. But then after we talk about the 401k and the pension and maybe the IRA and things like that, then we start talking about their estate planning. Okay, well, God forbid something happened to you. Where do you want this money to go? Who's on the deed at your house? What other physical assets do you have in your house? Whether you have like Tommy said, you have a gun safe, you have precious metals that you're holding in a safety deposit box, and all of those things come into play. And that's why, in my opinion, I think you need a good financial advisor, and you need a good, estate planning attorney to help you through that process. Obviously, now I have my health insurance licenses. I have my life insurance licenses and all of my securities licenses. I don't really like to touch health insurance. I'm sure all of you are probably in that same boat. Health insurance is it's very complicated. It seems like the rates are always the rates. You never get to shop around. It's always the same. But you definitely have some options, and you're going to have some choices to make when you get to the end of your retirement, as far as your health insurance. Now, sometimes the city, the state, they have some options for you to continue with their health insurance, and sometimes that ends up being a good idea, especially for workers that might retire before they're 65 years old and before you can get on regular Medicare. But if those are also some things that I can help assist with as far as getting you to the right place. As far as wealth transfer, again, that goes back to a lot of what Tommy was talking about. And I know the estate tax is very high for most people, but it is good to talk about where you want your money to be transferred to. God forbid something happened to you, and so that's why you have the ability to have beneficiaries on most of your retirement accounts. In Florida, in the state of Florida, you have the ability for anyone to be your beneficiary. It does not have to be your spouse, at least on your personal retirement accounts and your personal investment accounts. So some of those things, definitely come up into play. So those were a lot of the things that I wanted to talk about. Let's see what else we've got on here. Investment returns and things. I'm not going to get into some of these. The cost of waiting, and fees and things like that. But what I would like to do is I would like to give you a little bit of an overview on the market and what you've seen over the last several years. And again, you can have the slideshow that has some good information in here, but I think that everybody would probably like to kind of hear, or at least in my opinion, what's going on in the world. What's happened since COVID? Why are interest rates so high? Are we in a recession? There's a war that's brewing up in the Middle East again. So just to come back a little bit, let's go back to COVID. COVID was a terrible virus that affected the whole world, and during that time, our government and this is this is absolutely not political. I don't like to talk politics. I don't like politics at all. But what happened is our government ended up passing out a lot of money, a lot of stimulus to help people through the COVID years. Guess who got more money than anyone else? The big companies. The biggest companies got the most money. And what did they do with it? They padded their balance sheets, and what that caused was a rapid spike in the stock market during COVID and the year after COVID, 20 and 21. And so what you saw last year in 2022 was a very large inflation of stocks in the stock market. They were overvalued. Things have not been trading. Uh, the stock market has not been trading on fundamentals for several years. And so what you saw last year in 2022 was a large correction in the market due to not trading on fundamentals. I'll give you a perfect example. Delta Airlines. Delta Airlines filed a $19 billion loss in I think it was 2020. And I say billion with a B as in boy. $19 billion. Their stock price tripled in 2020. It went from 12 to 40. That made no sense. It absolutely no sense that they could file a $19 billion loss and their stock price triple in value. That's an example of what was going on in the stock market. And they're not the only ones, but I guess what happens in the long run is, investors and ultimately regular taxpayers like us, we have to foot the bill later on. And that's exactly what's happening now. Last year, we saw that large correction. If you were invested in stocks, bonds, any mutual fund, everything possible was down. Everything was negative across the board. So what you saw this year was some of that start to come back. Now, granted, what that did to the economy was it almost put us into an absolute recession. And if the Federal Reserve had not continued to increase interest rates as they did, then we would have absolutely been in a recession, and we still would be. I do not think that we're in a recession, but we are in some very inflationary times. If you've been, obviously, I know if you go to the store, your price of milk is higher. The price of meat is higher. If you go, obviously, gas prices are higher. Those are signs of higher interest rates and inflation. If you've got some money and you're going down to the credit union to pick up a 1-year CD, you're extremely happy because you're probably getting over 5% interest on a 1-year CD investment. But the guy that's going down there to try to get a car loan or to buy a house, that's not as fun of a trip for him because now he's having to get an interest rate of anywhere from 7 to even 9% on a debt loan. So it's a two-sided sword to that. Having said all that, and again, in my opinion, I will say that I do believe that we're done seeing rate hikes for the most part. It's possible that we could see one more 25-point rate hike, but they really have curbed this inflation, and in doing so, the goal of what they have done is to slow down the economy. That's naturally what happens. And I hope that I know that a lot of that sounded negative, but I do believe, I strongly believe that the next 1 to 2 years will be 2 to 3 very good years in our market. Again, I can go into more detail if you want to talk stocks or bonds. But I would say I think everybody has a great opportunity right now with fixed interest rates. If you can get something locked in for anywhere even from 1 to 3 to 4 to 5 years, because the interest rates that you're seeing right now, you will not see those 5 years from now. You absolutely won't. We haven't seen rates this high since 2007. And that was, 16 years ago. So, interest rates go in a pattern. And I think that we're getting to the top of that pattern at this point. It's great if you can lock into something now, but if not, just be patient. The rates should start to move back down a little bit next year, but I do think that the stock market will have 2 very, very good years to come. That's really the most of my presentation. I hope that I covered everything you wanted to hear. I'm happy to answer any questions. I really appreciate Amy and Tommy. I really appreciate you including me on this. I always love getting on these. Thank you very much.
No, thank you. Thank you, Chad. And thank you so much, Tommy. Excellent information it is. I mean, all topics, right? Even if we had 10 hours to discuss it, we'd still just be scratching the surface. So I really appreciate it. I do want to open it up to any questions people have, again, you can go down to your controls, or if your controls are at the top of your Zoom window there, and click on chat. If you don't see it right away, there are 3 dots with the word more. Click on that and you should be able to see a chat box. I do see someone asked, what is the link info to rewatch the recorded webinar? So you can go to mypensacolacu.com, and I believe it's /legal webinars. I will do that one moment here in a second, because that's called a vanity URL, and we've been making some changes to the website, so I want to make sure that is the exact page. So let me do that in a moment here and click over. And while I'll do that in a moment, because I actually had a question, one for you, Tommy, and one for you, Chad. So Tommy, if you would please unmute just for a moment.
Yes,
Thank
ma'am.
you. Hi. So I was curious, especially in the state of Florida, there's people who have homes in other states. And you were saying that the state of Florida will recognize any other state's will, but other states don't necessarily recognize a Florida will. Did I get that correct?
I can't say that they will or won't. I'm only
Okay.
licensed in Florida, so they may
Okay.
not. You'd have to refer to an attorney that's licensed in that area,
Good to
or
know.
in that state, rather.
Oh, perfect. So let's just say the scenario is I'm living in a state that will not recognize a will in Florida, but I have my primary residence in that state, yet I have assets and my will was written in Florida. Is that really muddy, or how could that work out?
What would typically happen is they would just assume that your will is either not valid or whatever it is. So if you don't, a will requires 2 witnesses and a notary. The notary has to be, they have to qualify to be a certified notary. The witness can't be one of the notaries. So, at the end of the day, let's say that you have an improperly done will. There aren't any witnesses, or it was never signed. Well, it's not really a valid will. So, worst case scenario, they go back to the laws of intestate succession in Florida.
Okay.
So if a will came here and let's say it's not validly done, they'll just assume there was no will, and oftentimes, and then just pass it through intestate succession under Florida statute. And it's a bunch of pages. It's like 100 pages in very small font. But however it would shake out in there, depending on how many children and non-children and family members, in the order in which it's supposed to be.
Got you. That's why we have people like you to read those 100 pages of very, right?
It's really fun work.
Right. No, excellent. Thank you so much. Thank you so
Yes, ma'am.
much. Chad, before I go to a question for you, yes, I was correct. My memory served me correctly that it's still in operation. It is mypensacolacu.com /legal webinars. And it actually takes you to the My Pensacola blog page, where we have, like, for example, at the top right now, we're talking about how we're looking to reach 100 sponsored this holiday season for the Wreaths Across America. But then you'll also see the next article in the blog is about actually tonight's webinar. And what I'll do when I have the recording after tonight is done, I will upload the new video, change that header to say, watch our pre-recorded webinars. But even if you clicked on that right now, you would still be able to scroll down past tonight's information to go to the previous webinar. So that's where you can always provide the link. And like I said, anyone who registered, I will also be sending out the link to thank you for coming this evening. So Chad, I have a question for you, if you wouldn't mind unmuting. And then if other people have questions, please start populating that chat. I just thought these were questions that might be interested, others would be interested in as well. Working in credit unions too, one thing that I've experienced, and maybe you have as well as a financial advisor, that there might be a misnomer that in order to really make a stride in your savings, you should have a lot of money to put in, like an investment, like a certificate. I mean, you were talking about rates are excellent. My Pensacola, we've got excellent certificate rates right now. And we're going to have a special coming up here as well on Halloween to really do a burst as well, because we want our members to be financially, healthy. Can you give any advice to folks to saying, even if you have the minimum about, let's say it's $1,000 to open something, that it's worth doing it? Because over time, every penny counts. I don't want to put words in your mouth, but that misnomer, I have to have $10,000, $50,000 to even start making a dent in my future.
Yeah, listen, everybody has to start somewhere. I run 401ks for large companies. I run small business retirement plans for small companies. I have clients that have $10 million, and I have clients that have less than $1,000. I've never in my career turned away a client for a minimum account value. you can open an whether if you want to do an IRA at the credit union and attach it to a CD rate, that's great. Typically I believe in the market growth and that kind of thing over time. And my money managers, I mean, you can start an IRA out with $25, and you can do a monthly contribution until you get up to $250, where you can actually buy into a mutual fund. So everybody can do it. I mean, I've got some of my largest clients want me to continue to educate their grandkids, or they want to put money into a 529 education savings account, for their kids. If there's one lesson that I've ever learned in my career, you don't ever turn away a client based on account size, because you never know when their grandmother or grandfather is going to pass away and they're going to inherit $1 million. So I try to treat everybody the exact same. And I'll tell you something else. Everybody's money, whether you have $1,000 in your pocket or $1 million in your pocket, it all matters the same. It's all relative. I mean, my $10 matters just as much to me as Tommy's, $10,000 in his pocket, and so on and so forth. So, the value of someone else's money is relative. It's all relative. Please don't ever, and that not just for me, for any advisor, don't ever let an advisor, number one, talk over your head and act like they're smarter than you, and try. That's why I try not to get into the details, because nobody wants to be talked over. They want to be educated. They want to be helped. And that's what I kind of pride myself on doing that. So yeah, it's a good question.
Wonderful. Thank you. We do have another question. I'm actually going to stop the recording at this time so people feel even more free maybe to ask questions. So I'm going to stop